Good evening and welcome to Slam the Gavel, the show that tells all regarding family court, criminal court, and other court issues, as well as CPS. I am your host, Maryann Petri. You can find me, my books, and blogs on dismantlingfamilycourtcorruption.com, as well as on Amazon. My third book, Raised by These Wolves, Volume 3, has come out as a bestseller, and it's also in audio as well. Now, I've got two brand new guests on. I'm happy to have Bob Terrien on, as well as Don Wenger on, and we're going to talk about veteranhope.org and the history of the loophole in 42 U.S.C. subsection 659. Now, there's a loophole in section 659 of Title 42 that states are using to make money by converting veteran benefits into state revenue. It says that veteran benefits received by military retirees can be garnished if the retiree has waived military pay to receive compensation benefits from the VA. It should say that all VA benefits are exempt from Title 4D, regardless of whether the veteran is retired or not. Congress has exercised constitutional power to make it clear that veteran benefits have always been totally exempt from state jurisdiction. Now, ever since Rose versus Rose decision in 1987, states have been going after veteran benefits to improve Title 4D revenue and circumvent the U.S.F.S.P.A., which is the United States Former Spouses Protection Act. I welcome you, Bob and Dawn. I'm glad we're having this discussion. How are you?
Good. Happy to be
Doing
here.
well.
Appreciate having a chance to speak with you.
I'm glad we all spoke about all this because I do talk to a lot of veterans and there is a lot of problems. And as we were talking earlier, that, veterans appear to be targeted by the system more than the average person, possibly.
Well, veterans have a divorce rate that's approximately double the national average. And a big part of that is because a lot of the veterans who go through that are the ones who are disabled in military service. But it takes a while to get a VA claim processed. So many of them have problems with employment and family breaking up during the time they're waiting or going through that. Some of them
Hmm.
don't even know that they need to. So it's a real tough situation. But when they do have benefits because of disability from military service, they're vulnerable to this family court system because the court knows where that money is coming from and they just look at it as easy pickings. Active military families are receiving pay and uh, allowances from the government through military service.
Hmm.
And the state courts presume to have jurisdiction over that pay and the allowances, even though the law says they're not available. But then again, when you look at military retirees, they're targeted as veterans because they have retired pay on one hand and veteran benefits on the other.
Mm.
And I was wrong. The USFSPA is actually the Uniform Services Former Spouses Protection Act. And sometimes it's easy to say that too many times fast and get tongue-tied. But I'm going to call it the FSPA for short, or
Okay.
the Former Spouses Act. Um, in history of this, there was a Supreme Court decision in McCarty versus McCarty, 1981, where the court pointed out that states don't have jurisdiction to just change or to take control of um, military retired pay and divide it as property. And this was a California case, which is a community property state. So in 1982, Congress said that community property states can look at the time spent in the military at the same time of a marriage and call that community property. And that could be treated as something that could be divided by the divorce court. Um, that's really the focus of the Former Spouses Act. Congress did not cancel federal preemption What they did was they made a small window to say community property states are allowed to do this. Otherwise, the only thing they can do is look at it as income for alimony or child support if necessary. So they're limited to the definition of disposable retired pay, which is in the Former Spouses Act and has always been there. And in uh, Mansell versus Mansell, 1989 Supreme Court case, the court said it is the plain and precise language of that statute that controls what states are allowed to do. States don't have jurisdiction to make up their own rules. They're limited to exactly what the law says. And where veterans are concerned, other than retirees,
Mhm.
um, the veteran benefits from the Revolutionary War up to now have never been assigned to states. States have never been given jurisdiction to decide who gets the benefits, where the money goes, who's obligated to use that money. States have never been given power to decide how benefits would be distributed between veterans and their dependent family members when they go through a divorce and there's a split. Veteran benefits have never been allowed for alimony. So everything that they're doing to manipulate the Former Spouses Act to get around the Veterans Judicial Review Act is an act of fraud. It is
Mhm.
predatory fraud against people with disabilities, and it is focused on stealing federal funds because what we're getting to is the family court is corrupted by the opportunity to get federal funding, lots of federal funding, by doctoring their books to say we're making and enforcing child support. And they claim it's child support, but they don't respect the law that says they can't touch veteran benefits under any circumstances. And the Former Spouses Act is only a small window. It's not jurisdiction on everything. It's a small window to say this is what you're allowed to do. And so what we know that the whole family court system is driven by this financial opportunity, and the Title 4D state agencies are funded by this money that they get out of the incentive payment structure of Title 4D. And when you're looking at military or veteran families, Section 659 says what federal payroll can be treated as income for alimony and child support. And it says that it's always said that veteran benefits have been exempt, except for this little bit about retirees. But in 1988, after the Rose versus Rose decision, Congress changed the jurisdiction statute in Title 38, making it clear that it doesn't matter whether the veteran's a retiree or not. These benefits cannot be touched by anyone. So what we're focused on is the military and veteran community to lift the lid on that can of worms and expose the corruption for what it is. And it opens the door for us to go after the other damages and the other problems created by this family court corruption. So we appreciate the opportunity to speak with you about this and to give you a bigger picture of a very small part of what we're doing to solve this problem. This is a tip of the iceberg thing, but it's a multi-billion dollar a year iceberg.
Oh,
So
it is. It is. And I was looking through laws and things like that, and I found, now this is really evil because this whole system thing is evil. It's 42 U.S. Code subsection 666, requirement of statutorily prescribed procedures to improve effectiveness of child support enforcement. Here it is right there. I think that's just so, this is so evil what's going on and what they're doing to people, and especially veterans who have fought for our country and getting treated like this.
yes, but this is also, like I said, veterans have a divorce rate that's almost double the national average. So we are a big crowd of people that are easy pickings for the states. They
Mhm.
look at Section 666 and they look at Section 659, and they basically mix everything up to make it confusing and difficult for us. But what we've been publishing, what we've been standing on is that the whole Title 4D program was created in 1975 to reduce the cost of federal spending on one hand and uh, strengthen the child support enforcement system on the other hand. But the problem really is that from 1935 to 1975, the federal government paid 90% of the cost of child welfare under the Social Security Act, Title IV. And in 1975, that went down to 75%, but Congress created a incentive competition that's based on the performance of the states making more child support orders and enforcing more child support orders. And then in 1996, they reduced it again to 66% and expanded this. So instead of just going after fathers with children on the welfare system, they went after everybody, whether they had children on the welfare system or not.
Mhm.
If there was a child support order or a request for child support enforcement, they would go after them. And this has become a money machine that grinds our children in order to generate state revenue
Mhm.
out of these parents. Part E of Title IV is based on taking children out of the home and collecting money from the parents to pay for adoption and foster care.
Mhm.
And when we look at the military and veteran community, this is not a small thing. We're just a large population within that mix that definitively has federal funds coming that the states believe should go to them. And the problem is children suffer an awful lot of damage and harm and pain when they're being used as pawns in this game over money between the parents. And we don't see this because the lawyers make it look like it's just the mom and dad, but it really is the lawyers and the courts
Mhm.
pitting everybody in this battle so they can make the money. And then children suffer a great deal more when they're stripped of their parents by suicide because the parents can't fight back against this. And it's much more among the veteran community because this comes down to a simple predatory embezzlement of veteran benefits because they're converted to state revenue. And that's what we're trying to stop. If we can stop that fraudulent conversion to state revenue, that will protect the whole family by saving the veterans' lives. That will help and protect those children. So that's the goal of Veteran Hope. And uh, Don and I are working pretty hard on that. I want to give him some space to explain the 3 points that we're doing, which is first, cases in the court system addressing due process of law and addressing this fraud. Bill before members of Congress and um, request to change VA policy so that it conforms to statutory law. We have several cases in progress that are focused on holding judges accountable for due process of law, which
Mhm.
is not just a yabba dabba do, you get to speak to the court. Due process of law
Mhm.
is a system of making a list on paper of the laws that apply protection to the individuals in the court. And we all have rights under the Constitution. We all have rights established by federal law specific to our circumstances. People with disability have a law that says that they can't touch these disability benefits. That law is enforceable as a right under the Constitution. Don, do we have your voice yet?
I don't know. Can you hear me now?
I can hear
I
you.
can hear you. Okay.
Okay.
So I'll
Uh,
let you take over and talk about that
since you
aspect.
touched on the FSPA and disposable retired pay, explain what retired pay is. Disposable retired pay is that portion of the service member's base pay based on his or her years of service or points as a reservist. So what's usually if you do just 20 years, you get 50% of your base pay. Well, until 2018. You get 50% of your base pay. So if you retire as an E7, whatever your base pay is at the time of retirement, you get 50% of that pre-tax. And then after tax is what your disposable retired pay is.
Mm.
And so what the states will do is they'll disperse a portion of that disposable retired pay based on the court order. So if the court order says that the ex-spouse gets 15% of that 50%, then that's what's paid. But what happens is a lot of time the service members will, the service departments will grant them combat related special compensation in lieu of their retired pay if they have a service connected injury that's considered combat related. And that is not considered disposable retired pay, but the states are taking that anyway and forcing the payment to the former spouse, and they're also using it for child support and alimony, which is a violation of federal law because, as Bob pointed out, the only thing in the Former Spouse Protection Act states that they can disperse is disposable retired pay, and it's a very clear-cut definition. It's only a portion of what is actually retired pay. And also a lot of people don't realize that the states make up their own laws. They say if it looks like income, it's income. California is one of those. They have a California Judges Bench Guide where they advise judges to how to go about calculating child support and alimony. California says if it looks like pay, it's pay.
Mm-hmm.
But
Mm-hmm.
they can't preempt federal law.
Could
I'd
they?
like to step in and it looks like you might have a question, but I wanted to quickly clarify. A big part of this comes under that section 666, which is the procedure for the support enforcement system. And I want to be clear, Title 4D was created to bring money back to the states to offset the cost of welfare. So initially, the reduction in federal funding for child welfare was just a set amount. The number of children that were on the welfare system because of the wars and poverty and general problems in society really increased so much between 1961 and 1971 that the federal government said, wow, this is too expensive. We're not going to do this anymore. So Part D was created to give states a competition, an opportunity to compete for the money out of a bucket. And they said the bucket is fixed. This is how big the bucket is. You get to compete for that money. And that competition is the system that is Title 4D, which goes from Section 651 to Section 669 of the United States Code, Title 42. The number system of the Social Security Act began in 1935 under the statutes at large. And so the numbers in the old law are 451 to 469A. So it's a little bit tricky having to look at both sets of numbers. We're just going to call it 659. We're going to stay in the 600s because we can see that in the United States Code. It's easy to find. It's easy to look up. But when we're looking at this, the things that Don pointed out about retired pay and about combat-related special compensation also relate to veteran benefits, because the process of getting out of the military because of disability or having disability, it takes time to evaluate. And during that time, a lot of the families are struggling financially and they go through the divorce. And that's when the family court says, oh, goody, it doesn't matter what happens. We're going to make sure that we can come back and leverage the whole thing so that the state makes money.
Mm-hmm.
Texas has a law, it's not the only one, but it has a particular law that says that placement of children and child support enforcement calculations or child support calculations are to generate the most revenue under Title 4D that the state can get. The judge's bench book in Texas and in California say that even if a service member is not receiving active military housing allowance, you have to use that number as if it was there because um, it could be there if the veteran, if the service member has family members. And they just assume that they control all this. But
Mhm.
all of these things are exempt from Title 4D, not because Section 666 or 659 says so. They're exempt because the laws that govern military pay, retired pay, and veteran benefits are positive law titles that belong exclusively to Congress and to the authorities that Congress has assigned them to, the departments of the military, the Veterans Administration, and the federal courts. There's no room for the state courts to have authority to touch those things. So our focus is on bringing that out and showing that the state courts are breaking those laws in
Mhm.
violation of the rights that belong to the service members, retirees, and veterans, and ultimately the rights of the whole family, because the law makes these things separate to protect the whole family from predatory scumbag lawyers who make ambulance chasers look good. These are the
Yeah.
worst lawyers in the country, and some of them have made millions of dollars corrupting this law and playing this game and screwing these families to death. And when a veteran dies by suicide because of this, or because or homeless because of this,
Mm-hmm.
the VA does not pay benefits for the dependents. The money disappears with the veteran's death because it's not considered a service-connected death. Suicide over child support is not a service-connected death. And this is the problem. The family that goes from being on welfare to getting this gravy train idea that they're going to get paid out of veteran benefits to getting nothing and going back on welfare when the veteran dies, that doesn't help the children.
Mm-mm.
Again, the children suffer not just from the abuse of the game, but from the loss of their parents. And we've been following Robert Garza,
Mm-hmm.
who is promoting 50-50 parenting and to say, take the money and put it on one side, deal with that separately. Look at parenting because children need both of their parents to the best of their availability. And historically, when parents are working, um, they should be able to say, okay, you watch the kids while I'm working, you watch the kids while I'm working, whatever the case may be, whether they stay together or get apart, it doesn't change the fact that children need their parents. And parents need to know that their children are safe and well cared for. And they should be able to trust each other even if they are split up.
Mm-hmm.
But this game has been directed at blaming the other parent for this being cut off and being separated, and blaming the other parent for losing time with the children. And all of that revolves around the idea of getting the money out of the system. So coming back to the veteran specific part, military retired pay is about um, service members who've been in the military and are either uh, retired because of disability or retired because they've spent a long time in the military.
Mm-hmm.
The law about that is federal. State has no authority to touch it. So we're focused on bringing that to the attention of the Supreme Court and pointing out that the Supreme Court has already decided and explained that in previous cases. We're asking them to point out that states are still required to obey that law. And Don's case is currently in front of the United States Supreme Court on the question of whether state judges are required to obey the definition of disposable retired pay in the plain language of the Former Spouses Act. And
Mm-hmm.
then whether state judges are required to obey the complete preemption of state jurisdiction in the veteran law, Title 38. And then the next question is whether states can be sued, or whether state judges can be sued for money for violating the rights of the individual they have no jurisdiction to touch. So where state judges have no jurisdiction on a subject matter, they have no excuse for violating the law that says they can't touch it.
Right.
And so that's the path that we're taking in the court. The other path is that Don and I have spent a lot of time interacting with members of Congress and their staff to put forward a bill to close this loophole in Section 659. The loophole says veteran benefits can be garnished if they're going to a retiree who has waived retired pay to get them. It should say, doesn't matter whether he's a retiree or not, veteran benefits are exempt. And right now, VA policy is allowing veteran benefits to be garnished for alimony and child support. And a big part of this is that money is not really necessarily going to the family members or to benefit the children in any way. Most of the money being garnished from VA benefits, Social Security, combat-related special compensation is going to the state to repay the state for the welfare program the family, the children have been on. So all of this revolves around child welfare, and the Title 4D is the corruption point that has made the family court into a money machine that is tearing up our children, grinding up their lives, stealing money from them. And all we're pointing out is that due process of law does not take anything away from our children. If the veteran has the money and the home and the food, the children benefit because they're right there. But if you steal the children to steal the money, the
Right.
children are getting hurt.
And these courts don't care. And I was going to ask Dawn, with your case, I don't know if they imputed a figure that you don't make, or in the military, can a judge just impute an income that never existed?
Well, in my case, I was in the reserve. I spent 36 years in the Marine Corps Reserve, and so I hadn't yet retired, but I was already rated as a disabled veteran. And the court took that money and said, we're going to calculate this. And of course, I didn't have enough once they did that, so I was forced to go get a job. And what happens when they do this to veterans, veterans who have disabilities, is that it exacerbates their injuries. Some people, if they have problems with mobility, and they go to work where they have to walk around a warehouse, which I did. I had to go to a job where I was wearing steel toe shoes and just put more damage on my body. And that just exacerbates the injuries, but the courts don't care. And there are several other service members that are, that have severe PTSD and other issues where they have difficulty sleeping and functioning day to day. But the courts, they look at that money and they say, oh, we're gonna take that and we're gonna use that. So it just makes the situation worse. And something Bob touched on it. People, when veterans say, hey, you can't use this, people look, the first thing they say is, what about the kids? It's usually the social workers or the attorneys and some of the former spouses that say, what about the kids? Well, what happens if the service member, the only thing he or she has is the veteran disability compensation so that they can maintain their, their car and their rent or mortgage and other bills, and you take that away and give it to somebody else, the able-bodied person, then the service member, the veteran, winds up homeless, sleeping in a car, sleeping underneath a bridge, or sleeping in a cardboard box. And eventually the person winds up taking his or her life. And also when that happens, the court will look at it and they'll go, well, we can't give you partial custody. You don't have a place to house the kids. Yeah, because you did that to me. But
Right.
the judges don't care. And then the children wind up with only one parent. Then you can ask the question, what about the kids? Having the veteran keep his or her money so they can take care of the kids when they're with him or her, that is taking care of the kids. But people think they immediately leap to, oh, he or she doesn't want to take care of the children, which is just ridiculous. And another thing I wanted to point out is in 42 U.S.C. section 659, that language in there is dead letter law. And we presented this to Congress, many members of Congress, and they immediately go ask a lawyer friend, or they'll jump to the internet and ask Google, and they'll get this AI answer that tells them, oh yeah, it can be used. And the problem is they don't understand. Nothing in Title 42 can override Title 38. Title 38 is positive law and makes it very clear that veteran benefits can't be touched.
Another thing I'd like to mention is that, we get into talking about this a lot of times. It's easy to get into the technical language and say subject matter jurisdiction and preemption and things like that. But those are fancy words that say that really mean, when you're looking at something like Title 10, which is the Armed Forces of the United States, that comes under Article 1, Section 8 of the Constitution. Congress controls every aspect of that subject matter of federal law. So when we talk about subject matter jurisdiction, every different title or every different box of the law is separate from every other one, but they're all combined into there's an expression, all law supports all law. So the entire legal system is integrated with multiple boxes of what can be looked at or dealt with. Title 38 is totally separate from Title 10. You don't get to Title 38 without service in the military under Title 10 or one of the other ones closely related to it. But it's a separate subject matter of law with its own definition of jurisdiction. And jurisdiction is the ability of a court or the ability of an authority to speak the law. Juris, law, diction, speak. So lawyer talk is what we hear a lot of. And we've all heard the babbling nonsense and the bouncing circular logic that comes out of the family court and comes out of the lawyers. And it just becomes more and more and more babbling nonsense. And I'd like to use my other favorite word in the world, but I'm refraining from that at the moment. So we hear this stuff and we get very much overloaded.
Mhm.
Our program is meant to make it easy to understand. Certain things are separate and exempt from state jurisdiction. So even though states can make alimony and child support orders, they can't touch the subject of veteran benefits. They cannot touch the subject of the military housing allowances. They cannot touch the subject of combat-related special compensation because those are defined in very clear, specific words and structure in positive law, which is legal evidence of the supreme law of the land. And judges are required to obey the supreme law of the land, which is defined in Article 6 of the Constitution, which says that this Constitution and federal law in pursuance thereof and all treaties of the United States or which shall be made by the United States are the supreme law of the land. Judges in every state are bound by this as the supreme law of the land, notwithstanding anything in the Constitution or laws of a state. So in easier words, they're required to obey the Constitution and laws of the United States and treaties of the United States, whether they like it or not. So
But the
we
judges
want to
don't
hold them
care.
accountable.
They're looking at
Of course they do,
dollars,
because they think they
amounts.
can get away with it. I'm
Right.
sorry.
You're fine. Yeah, you have here that, they name one parent as custodial and the other one as non-custodial. And people should know that you're already labeled like that even before you go in there. People need to know how bad these family courtrooms are. And this plants the seed of the resentment that grows into the parental alienation that you were talking about earlier. And they make one parent look horrible and limit residential time, and then blaming that on the failure to pay, which, as you said, put them in this position to begin with.
And what happens with that is when they label one parent as the custodial parent, the children, especially when parental alienation is involved, the the children tend to think that that custodial parent is the superior parent, so they tend
Mhm.
to show disrespect toward that non-custodial parent. They're the parent with less custody and less time, so they think that person is inferior.
And
That's a good point.
frequently in that situation, the so-called custodial parent, both parents will sometimes, they have arguments before they split up, but then they also have arguments over the children and over managing the children and managing everything else. In many, many cases, they badmouth the other parent so much that the children get they go through a sort of a numbing effect, but they get to the point where they just start mimicking it. And in some cases, they resent the parent they live with because whenever they do see the other one, it's like a heaven's vacation because everything is dedicated to their happiness for that really brief period of time. But they learn to resent the other parent, even though it seems like everything's gravy train and when they're there, because they think that the other parent doesn't want them most of the time.
Mhm.
And they're conditioned by hearing all of this bad language. And that is difficult enough. But when you have a parent who is really neglectful
Mhm.
or otherwise abusive, and you have children in situations of danger. For example, one of the veterans in our program has been concerned about a child being trafficked into a gang environment, and that just that is crushing. And
Mhm.
he went to the police and he made the report and went to the hospital with the child and went through the process, and yet the other parent filed charges of custodial interference and false accusations of abuse, even though it was already recorded. And basically, the veteran ended up in the court on a contempt charge over the custodial interference and almost went to jail, but
Mhm.
basically was able to point to the judge the police report and the medical history and still does not have custody of the
Mhm.
child, but did not end up going to jail at that point in time. That veteran's already been to jail a couple of times besides that. Other veterans have been going to jail over alimony
Mhm.
orders um, and things that they call indemnification, which is a language that says if a veteran that's a retiree doesn't make up the difference by paying out of veteran benefits, um, they hold him in contempt, whether it's an alimony order or a former spouses act division of property. And so veterans have been put in jail to manipulate them for this money many times. The we see what happens to us. In my case, I was in and out of the hospital. I was homeless on and off again through the 1990s. I was struggling with a lot of the pain and stress of just getting from one day to the next and having this this child support order that was based on a fairy tale that I was
Mhm.
lying about disability, even though the federal government made it clear in its decision that my disability was because of military service and that made it exempt from this. The state still embezzled half of my disability benefits, leaving me with less than $600 a month to live on, which
Oh.
made me homeless again. And I went through all of this uh, after being stripped of my children because my ex-wife remarried and moved to another state, and I had no idea.
Mm.
I was struggling. We all blame the former spouse at some point, But what we want people to learn is it's not the former spouse that's really the cause of this. The heart of this problem is the lawyers and the Title 4D state agencies. In some cases, the state legislatures are breaking the law to get this money. And they systematically go after families of all kinds. Veterans are just more prone to suicide because of the higher divorce rate and the higher rate of these problems. Um, I'm not the only person who's spoken out about this, but I have taken the language that other people have published on this since the early 2000s when I was homeless because of this. Um, but I've taken the stories that other people have told about this, and I've made it easier to understand so that we can focus on the real problem, which is the lawyers and state officials and judges who are doing this, and to say, look, the law is actually in our favor, but we have to understand a little bit of it to be able to claim the rights in order to get federal enforcement of due process of law. And that's the direction we're going on the courts. Fixing this loophole in Section 659 will help make it clear that states do not make any money off of veteran benefits one way or the other. When they um, are looking at divorce and alimony and child support, they simply cannot look at veteran benefits as part of that. They cannot look at combat related special compensation. They cannot look at housing allowance or subsistence allowance for active military. Everything they're doing is a fraud upon the United States of America by doctoring their books to scam the government out of money directly. And everything they collect out of veteran benefits, combat related special compensation, or housing allowance that goes to the state to repay the state for the cost of welfare
Mhm.
is an embezzlement.
Mhm.
And that's a lot to chew on, but
Well,
this is what makes it easy to understand.
mhm.
The Title 4D, the original idea of Title 4D was to collect money back to the state to offset the cost of welfare, which makes sense.
Mhm.
But states have corrupted that, turned that around into the money machine that grinds our children. And it's not just the parents that end up, the veterans that end up suicidal.
Mhm.
One of our members got a call from his son, and it was brought up in the courtroom that the 12-year-old younger brother had been hospitalized, apparently for the third time, for attempting to kill himself.
Mhm.
And these are country kids who have their own firearms and know how to use them. And this basically frosted the judge's Cheerios, and
Mhm.
she recused herself uh, from the case. The very next judge placed the children with the veteran father and said, "Hey, you need both parents. You need, this separation has to stop. This craziness has to stop." He now has custody, but the state is still
Mhm.
embezzling his federal disability benefits by converting it to state revenue, because while they were going through all this fight over the divorce and the child support and the custody, the ex-wife was milking the welfare system like it was going out of style. And
Mhm.
all of that built into the system of going after the veteran. And that is not just men.
Mhm.
Women veterans are treated even more aggressively than men veterans, because they couldn't possibly be a good mother if they've abandoned their children to have a career in the military. Oh my goodness. Um, which is one of the reasons that the female suicide rate per capita is almost 4 times the male rate per capita. So for every 1,000 men in the military who have suicide, uh, there's 4,000 women.
Mhm.
Perhaps that's, let me rephrase that a little bit differently. For every man who dies, not it's too hard to say, per capita,
Mhm.
for the rate of male suicides is 4 times the rate per capita of male suicides. That's the easy way to say it.
So it's hitting the female veterans harder.
It is, but
Yes.
you don't hear about it because it doesn't fit the narrative. The
Yep.
narrative is that people still hang on to this mentality that all women are like Harriet Nelson or June Cleaver, and they're staying at home while the husband is out earning money. So the attorneys capitalize on that. If they were able to figure out a way to turn that around, they wouldn't care which, whether it's the men or the women. If they could make more money off the women, they would. But, right now there's still more men in the workforce, especially in the military, than women. So they capitalize on that.
Mhm.
But you're not going to hear about the female veterans because it just doesn't fit the narrative.
Yeah, I didn't know that.
There are other portions of the general population and portions of the veteran population that have different specific experiences and trauma in the court system, but really, and if you didn't have PTSD when you go into divorce court, you're damn skippy going to have it when you come out of divorce court. It
Mhm.
is one of the worst places we experience bad language and very, very personal attack and abuse.
Mhm.
And ultimately, yeah, people fight. People get together, they get apart. People fight when they're trying to sort out money or when they're trying to sort out how to manage the children. But the state courts capitalize on that pain, that anger, that hardship, that stress, and they make money. The states make money
And so do the
on,
lawyers, and they keep this
and the
revolving door
lawyers
because they
make
have this
money.
continuous,
All we want to do is
motivation.
shut down that money machine and help the families by saving lives. So
And
that's the focus of Veteran Hope. Help the
if the
family by
courts would,
saving.
if there wasn't a money incentive involved, a lot of these people, even the people who are difficult, the ones who engage in parental alienation, they wouldn't there wouldn't be as much to fight about or things over which to be angry because the money part would be taken out of it. If there wasn't this incentive that, hey, if I just divorce, I can get alimony, I can get child support, whatever, then there would be fewer divorces. People
Mhm.
would either not get married because they wouldn't think, oh, if I'm dissatisfied, I can just divorce and get money, or they would stay in the marriage for the right reasons, and there would be um, fewer child suicides and fewer parental alienation cases.
A big part of this comes back to the language that we hear in the court and from the lawyers and in the animosity that we see from the judges who hate us just for being there, but they just want to milk us to death.
Mhm.
All parents are created equal. Some are just more equal than others, which you might recognize from Animal Farm. Um, the fact is that they use this inequality to
Mhm.
leverage the payment system. And it is that fraud that they commit that builds state revenue by destroying families.
This is
We'd
just
like to just basically say
yeah.
that parents should be able to manage child time as best their circumstances. A veteran that's disabled, maybe too disabled to actually manage the
Mhm.
children physically, might need to have more help from the other parent. But a veteran who can manage the children while the other parent, who's able-bodied, doesn't have any problem going to work, goes to work.
Mhm.
And then when you're when you're together, that's how you do it. I mean, uh, my daughter has 4 kids, and she works part-time. Her fiance works part-time, and they just go back and forth.
Mhm.
That's normal when people are together. What makes it so abnormal when people split up? Let's say um, you have people who split up. They still have the kids. They still live in the town. Granted, some move long distances. They still should be able to say, okay, part of the time the kids are here, part of the time the kids are there. And there should not be any kind of an opportunity for people to milk that for money.
Mhm.
The law about veteran benefits and retired pay and even alimony and divorce, the law is there to make it easy to protect the children from that fraud. But it has been corrupted. And one of the biggest problems is that judges uh, um, don't obey the law
Mhm.
because they think they can get away with it. And states encourage judges to make more money
Mhm.
playing this game. So states are motivated to keep breaking federal law. Judges are motivated to keep breaking federal law. We'd like to reduce that motivation by getting some in trouble and pointing out that breaking federal law, there's a line. They can break federal law up to a point. Federal preemption of state jurisdiction means the state judge has no jurisdiction to touch the federal subject. When the judge crosses that line, he gives up his authority, he gives up his immunity. When they cross the line of federal preemption, they go from being a judge in a robe on the bench to being an ordinary person in a Halloween costume sitting
Mhm.
up on a high chair.
Thank
It
you.
becomes a pretend. And so
Right.
that's what we're pointing out. When they cross that line, they should get in trouble. So that's what our cases are about. Our bill is about making it clear that states have no money to make off of veteran benefits and they have to just shut up and accept that fact.
Mhm.
And even though states get bazillions of dollars out of the federal government, they don't need to take more money out of veteran benefits or Social Security or housing allowance. They don't need that money. They're not entitled to it. They have no right to that money.
Mhm.
And ultimately, uh, current VA policy has been to allow veteran benefits to be garnished to 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 make child support payments, but the law says these benefits cannot be touched. So we want to get the VA.
VA is not following the law.
Yeah, we
Okay.
want to get the VA to make to conform to what the law itself says and to acknowledge and to publicly state. See, the Secretary of the VA could come out any day now and in one public statement say, gee whiz, I've just learned that the law says this, and that means that states have been breaking the law, stealing veteran benefits. You're done. That's all he has to say.
Mhm.
And it would work because it would be correct. And everything that I've published, that Don and I have presented to members of Congress, that even the other people that we've been working with over the years, um, has been accurate and correct. The problem is nobody's been able to survive long enough to get a judge in the hot seat. We've got 5 or 6 judges facing the Supreme Court on the question of whether they could be sued for breaking the law that says they could not possibly touch veteran benefits.
And there's this misconception. People think that veteran benefits were intended for the family because at one point there were, during the Rose decision in 1987, some of the justices opined that it was for the family, and apparently some members of Congress also did, but that is not written into the law. What somebody's opinion is different than what is written in positive law. Now, also, um, under the Code of Federal Regulations, it does mention garnishment. It says it can be garnished, and people have this misconception that garnishment means that it can be assigned. Garnishment of VA benefits can only happen, let's say a disabled veteran also has a job and the courts the courts will calculate child support and alimony off of that person's job. And then if he or she doesn't pay that child support or alimony out of that job, then they can take part of the veteran benefits.
That's a different thing. You're
Well,
kind of crossing the streams, Don. I want to respectfully say, where veteran benefits are concerned, they're just exempt from state jurisdiction. But if a veteran has a job, that job counts as income that could be garnished. Veteran benefits cannot be garnished, whether they have a job or not. But within Title 38, there is a provision that says veteran benefits can be apportioned by the VA, not by anybody else. The VA can make a payment out of the veteran's benefits to a dependent, either a current spouse or a former spouse with children, um, as long as, number one, it does not cause the veteran hardship. The veteran's already homeless. The answer is no. And in 2021, the VA put out a policy to cancel all incoming garnishment or apportionment claims because in the 2018-19 timeframe, roughly 30% of the claims on backlog at the VA were apportionment claims demanding alimony and child support from veteran benefits, and they were basically appealing those claims and clogging up the system so that veterans couldn't actually process disability claims or death claims
Mhm.
or education claims. And we went from the neighborhood of 150,000 claims to 750,000 claims at one point.
Mhm.
And apportionment claims making up more than 100,000 of those claims basically choked the system. And a lot of veterans died waiting to get through their own claim process. So the VA said, we're just not going to do that anymore. That was a good decision by the VA. The bad part was they said, but you know what? States can garnish once it hits the bank. States can
Mhm.
can file garnishment orders on veteran benefits directly. And the VA should be saying, no, those are illegal.
Mhm.
But you're right, Don, in that pointing out if a veteran is able to work anyways, whether they, regardless of whatever VA rating of disability they have, some veterans with even with 100% can do something productive. I mean, it doesn't mean we're just, we're useless. It
Mhm.
just means that the state cannot force us to produce money out of our VA benefits or to go back to work to produce money. The state cannot impute income against disability because that is a fraud. And the states cannot make any decision about how disabled a person is. If the VA says they're 50% disabled, the state cannot say they're 100% not disabled. If the VA says they're 100% disabled, the state cannot say, well, they can go make money anyways.
Mhm.
The state has no jurisdiction to decide whether the disabled veteran is disabled or not. Same thing applies to Social Security. If the Social Security Administration decides that a person has become disabled and is covered by the insurance or under SSI, the state court has no possibility of jurisdiction to say that that person is not disabled or to say that the state needs to decide whether that person is disabled. The state cannot demand the records of the veteran to decide whether he or she is disabled. The state cannot demand Social Security medical examination records to decide whether it believes that person can work or not. So these are points that we are making in the process of the work that we're doing. And I want to say, Maryann, you've been quiet, but you've also been very supportive in letting us present a lot of information. I don't want to um, go too long on this because once I start repeating myself, it's a downhill spiral
Uh,
as I get overloaded trying to say everything at one time. If there's more questions, if there's more opportunity to bring back more information, we're very happy to do that. Um,
right.
this information is on our website,
Mhm.
veteranhope.org. And our emails are so easy, you just can't even miss it. Bob@veteranhope.org, Don@veteranhope.org. And we have several veterans in process in the court systems, and we're supporting more getting lined up for this. We want to make sure that as your audience is getting this information, I don't expect you to just take my word for it. I want to make sure that everything that we've presented can be verified.
Mhm.
Um, it's important for people to understand that we're speaking very specific information and that we're correct in statement of fact and law. So I just want to make sure that we have a good presentation and say thank you for having us here. And if we have any questions I can address right now, I'd be happy to. Otherwise, we can also plan on the future if you have a chance to give us a point.
Oh, most definitely. This was very fascinating. And I did keep quiet because I knew there was a lot of information to get through because this is so serious. I didn't want to ask a whole lot of questions because I'm sure you have parents contacting you and, I'm sure it's overwhelming as well.
At times.
Yes. Well, yes, you're welcome back anytime, but don't jump off, okay? Slam the Gavel is a podcast to help the public understand what really goes on in these courtrooms. I'm your host, Maryann Petri. You can find me on Spotify, YouTube. Please like and subscribe, Apple iTunes, iHeartRadio, Google, and other platforms out there. Again, feel free to buy me a coffee to help keep this podcast going. Thank you so much, Bob Terrien and Don Wenger. Thank you so much.
Thank you for having us.
Thank you.
It's a pleasure. Thank you.